Hello, and thank you for joining Fairfax County Department of Cable and Consumer Services as we celebrate National Consumer Protection Week. My name is Michelle Thompson, and I'm a consumer specialist with the Fairfax County Consumer Affairs Branch. And as the Homeowner and Condominium Association Liaison, I'm excited to bring to you this workshop where we're going to talk about Virginia resale certificates and association disclosure packets. Truly, this process is definitely meant for the consumer. So for those who are involved with developing the packets and producing them to the seller, and then for the purchaser who actually gets the packet, we're going to talk about what's involved in that process and all of the detail that you get in that big packet at the closing. Joining me today is Amy T.H. Kessler. She is an attorney with Segan, Mason & Mason and has worked along with me on other educational programs, and I'm really excited to have her here today. Today we're streaming live on Facebook, so we're excited that you're joining us there. We have a lot of information to share, and we will get to most of your questions, I believe, in the presentation. However, if you have questions, please post them in the comments section on the Facebook on the Fairfax County Consumer Affairs Branch Facebook page. Also, for our viewing audience who are watching it on home during the replay, please go ahead and feel free to contact me with any follow-up questions. And thank you today for those who are in attendance. Today, we want you to be able to walk away with a few learning objectives. First of all, we want you to understand what the association's reporting requirements are with the Common Interest Community Board. We want you to understand the laws that govern the resale packets. One of my greatest things to say is always go to the source. And even though we provide you with handouts and references to a current law, whenever you are actively using it or reviewing it or preparing the packets, always go to the source to get the most recent information and forms. We're going to talk about the elements that must be included in the resale disclosure packets. You'll see there are about 18 to 19 different items that should be a part of that packet, and we'll talk about some of the pitfalls that individual associations can look out for as they're preparing them. And then finally, we'll talk about the methods of delivery for the packages and when you can charge fees and what those fees are. So first and foremost, if you are a mandatory common interest community, a condominium association or a homeowners association, in the law we call that the Property Owners Association, you are required to register with the Virginia Common Interest Community Board. On the left-hand side of your packet is information of the different forms that you have. If you have never registered with the board, the first form on the left-hand side is the actual registration application. Once you register, you're assigned a number that identifies you and your community. During the annual period, if there are any changes to what goes on in your community, for instance, maybe you have a change in the point of contact. If you're a self-managed community and perhaps maybe you hire a community manager, your point of contact will probably change. There's a form that you'll need to complete, and you'll send that in as an update. Also, if there's a board elections between the time that you register and your renewal period, you'll want to also submit the third form that's in your packet, an update of the names of the board members and their titles and addresses. Go to the source. On the Common Interest Community page, you'll see at the bottom the associations, the most commonly requested forms, the registration application, your annual renewal report, and your governing board changes and any changes in the point of contact. Okay? So today, homework is to make sure that you are properly registered. Well, Michelle, how do I do that? Well, let's look. So DPOR stands for the Department of Professional and Occupational Regulation. And they have various boards for different types of professions. So for instance, a lot of realtors will call me because they're looking for your contact information to request that resale certificate or the association disclosure packet. And so I'll send them to this board. They're familiar with it because that's where their licensing information is under the real estate board. You can actually look up your association name. If you know your number, you can put in your license number, although we reference it as a registration number here. And then if you select the different boards, it'll make your search go a lot quicker if you select the Common Interest Community Board. So when you go home this evening, your homework is to go in there, type in your name of your association, select the Common Interest Community Board, and look at your registration status. What will return as the search result is the name of your association, the address that's on file of where to contact you. So if you have a community manager, it may be the community manager's address, but that's the formal information that will be available to you. It will also show you your original registration number and your current expiration date. The reason that point of contact is important is because the renewal notice will be sent to that contact. So a tip to remember is, for some of our self-managed associations, is to remember that you don't want to necessarily have it go to one individual's address, because what if that person moves? If you have a central address for the association itself, then all these types of registration forms can come directly to whoever is in charge at the time, and then you won't lose your status by registering late or renewing late. And then we're going to be speaking more about the resale disclosure certificates and association disclosure packets. Again, another reason to go to the source. Historically, we track what's going on with the changes in the state law, and every year it appears that we always have some little tweak with some of the information that's related to these resale disclosures. So you do always want to go to the source. In each of these laws, for each of the different types of common interest communities, you will see detailed outline information on how to prepare the packets, what needs to be included, what the cancellation process is required, how to deliver, things that we're going to do a highlight today. But I give you these links so that you can do what? Go to the source, right? Okay, so as you get the packet, we know that the home purchasing process is very emotional. And by the time we get to these documents, we've already emotionally bought into the home. We've redecorated every room with all of our personal belongings. So this piece is so important, but many people overlook what's in it. So just let the buyer beware. This is specifically a consumer disclosure. It's going to tell you what you are responsible as an owner. So we have different people tuning in. We have buyers, we have sellers, we have real estate agents, realtors, we have volunteer board leaders, community managers. But for the buyer, this is very important information. And so the purpose of the assessments, if you're a first-time home buyer, you may not know that you have to pay this additional fee. You think you're just paying the mortgage. But you have this common area you're responsible for, and you're contributing to the maintenance of the services. You're actually contributing to a reserve account for future long-term capital projects that need to be completed, and all the other costs and expenses that are established in your individual community. So every community will have a different set of documents, and some things that are different and they change. So you also will get information about what are the consequences of the failure to pay. You just want to know that because it's one of your largest financial purchases that you're making, and you want to know all of the costs you have to account for. The declaration and governing documents are like another layer of documents that control the individual community as a whole. It gives the rules and regulations, the bylaws, what the officers of the community are required to do as they lead the community. And then one of the most specific issues are the architectural standards and guidelines. So when we purchase a home, we think our home is our castle and we can do anything we want with it. It's very important that we're reviewing what restrictions we have within this community. Some communities may have a specific color requirement for a particular shutter or door color or a certain type of window. They can get very specific. So you really want to take the time to review them as soon as you receive these packets. And then you have more information to determine whether or not this is a community you want to agree to commit to these standards and guidelines. And again, you'll hear information about what are the consequences for failing to comply with these governing documents, specifically these architectural guidelines. Let the buyer beware. You may want to come into this new home that you have, and you may want to be able to rent it out for additional income. There may be some restrictions in those documents that limit how you can use your property, whether or not you can rent the lot or your unit. If you have a boat, are you going to be able to park your boat on your driveway? Or are there some restrictions on what you can park on your driveway or in your yard? This information is very detailed. Again, sometimes during the process, it may get to a couple days before a settlement, but it's still worthy of reviewing. And what's happened before the actual purchaser receives is that the volunteer board leaders have taken the time to compile all of this information so that the consumer can make an educated decision and make a more informative decision about the finances related to purchasing in your particular community. If you're purchasing in a brand new community, it may still be under what we call developer control. And that's when the actual developer is in the process of building the homes and selling the homes, and they have a certain amount of time that they're going to be in charge before they transition over to owner leadership. So that is information you want to understand. So how long will that process be going on? And then when do we as owners transition into leading the community and taking over those responsibilities? And then finally, the important notice to purchasers. The documents that you receive are part of your legal contract with the community. You as the owner are purchasing, and you're agreeing to these legal requirements, and you may have the right to cancel if you review it in time and in detail. You'll have to review what's available and look at your purchase contract, but we'll talk a little bit more about the requirements for doing that. The document is trying to give you as much information as possible about what it means to purchase in a homeowners association community and what your responsibilities are. So some tips for owners and for the volunteer board members who may be developing the package. Some communities have made it that they will take on introducing themselves to the realtors who are posting for sale signs. Right? The process involves a lot of different players, so that if you know that a home is up for sale, you may contact that realtor, contact the owner. The owner should be reaching out probably to you for the request for those packets. But there's timeliness involved. When do you get paid for payments for completing the packet, if that's applicable to you? Building those relationships helps everyone stay on the timeline and to respond as quickly as possible to the request and as comprehensively as possible to get the information that everyone needs. But keeping in mind, as a purchaser, each of us is responsible for examining the information contained in. You may find a new person moves into the community, and it's a good thing to welcome them into the community and just to double check. Did you receive your resale disclosure packet? Because they're still going to be held accountable once they are owners. And then here's another way that you're just making sure that they have the information that they need to be a contributing member to your community. Okay, so at this time I'm going to pass it over to Amy, and she's going to talk about some of the pitfalls she's seen after working with different communities as they're developing their packets. Do you have any questions about the first section that we just reviewed? Yes.
Michelle, on the left side, the last sheet is for a community association annual report.
Yes.
What is that?
So once you register with the Common Interest Community Board, the association is required to register annually. So the first document was, if you have never registered, you'll complete that form and submit it to the Common Interest Community Board. Each year you will probably receive a follow-up notice to remind you to renew, and then that's the form you will complete to renew your registration status. Any other questions? Okay, great. Amy, I'll pass it to you.
All right, so what we've had listed here is pretty much everything you're going to have to include in that packet in short, condensed form. And I just wanted to hit on a couple things that may or may not have occurred to you or occurred to a purchaser as being a problem. The first one seems really obvious: association name and registered agent, right? That seems pretty straightforward. Except I can think of, off the top of my head, 4 different associations in Virginia with the name of Cedar Lakes. So there are several things like that that happen where common interest communities have similar names in different parts of the state. So the Pinecrest community in Virginia Beach is different from the Pinecrest community in Richmond, is different from the Pinecrest community in Northern Virginia. Except when you look them up, how are you supposed to distinguish, right? So it's really important that you always have your exact name as listed as your name in these DPO TPOR documents. Now, if you're incorporated, which most homeowners associations are, your exact name will be what you're incorporated at the State Corporation Commission as, and you can look that up in a similar way as looking at the DPOR licensing on the State Corporation Commission website. It's a very similar process. And in that situation, you can put in Cedar Lakes and it'll pull up all of them. So you don't have to know going in which one it is. The other thing you see sometimes is what the developer called the association and formally named it is not what you use as a community. So the way in it says Camelot Community, so you all call it Camelot, but it's actually King Arthur's Court Community Association. So again, you're going to need to know that official name because that's what you're going to be registered under and all these things. As to the declaration, bylaws, articles, and architectural guidelines, those are all things you're going to have to include in this packet, a copy of all those. That can be difficult because some of these documents can be really old and the copies are really bad. You can always go to land records in your community and get a new copy to make them fresh if you need to. Just for your own information, in HOAs, the declaration is the only thing that's recorded. So you're not going to be able to get the bylaws or the rules and regulations or anything like that from the land records. The articles of incorporation would be with the State Corporation Commission if you need those. Whereas in a condo, both the declaration and the bylaws are recorded. So again, if you need a copy of that, you can go to land records, but if nobody has a copy of the bylaws in an HOA, you may have to go back to some original owners, try to recreate some of that stuff. And then I would assume that most people would know if they're in a sub-association or a master association, but the number of people who do not is phenomenal. So you have something like, well, Reston is your best example. Reston Association is pretty much all of Reston, and there are a bazillion sub-associations. But usually what I tell people is if you're in a condominium or a townhouse, that's who you're going to see in a sub-association, because you'll have a master association that covers the entire community and then the sub for the condos and the townhouses. And they'll have to have their own resale packets or certificates. The CICB form, which is called the cover sheet, that's the form that you pull off the website that Michelle gave you earlier, and it lists all the things you need to include. And again, the filing certificate, certification, and license number are things you have to include in the resale package. You also have to have an official association complaint procedure. This was a change to the law, maybe 2012-13, that requires the association to adopt a formal complaint procedure for complaints that would go to the common interest community ombudsman. So there's a kind of basic layout for that in the statute, but you have to adopt that. So if somebody has a complaint, they have a procedure they can follow. And this only addresses legal issues. So for example, if somebody says you're not having open meetings as a board, that would be a legal issue that's required legally. If somebody says, I want Art Deco windows and you're only requiring colonial windows, well, that's individual to the association, and that's not going to be something the ombudsman can review. Michelle went over the assessments are required to be included, but also any mandatory fees. Some associations are also part of recreation associations, so there's an additional fee that's required that may or may not be an assessment, but is required. So those are all going to have to be laid out in the disclosure package, as well as any special assessments. And the post-closing fee that's charged by management is laid out here, and I'll go into that a little bit more in the fees, but you have to disclose that because this is going to be going to the purchaser. So the purchaser needs to know any fees that would be their individual responsibility. You also have to reveal the status of the seller's account. Is it delinquent? Are there violations? And you actually have more detailed information about that coming up. The association has to give its reserve study. The reserve study is required to be done every 5 years, and it outlines what needs to be done in the association, capital improvements, that sort of thing. It's actually a really good thing for associations to do, but it's something you want to give to purchasers so they can say, well, maybe there's not a special assessment this year, but in 2 years we're scheduled to repave the entire community. Also, the current budget, income and expense statement, the balance due on any outstanding loans, which usually is going to relate back to a special assessment, because if you're borrowing $50,000 to replace your elevators, you're probably going to specially assess that to all your owners. So that'll be kind of interrelated. And then insurance coverage, your fidelity bond, your individual insurance requirements for owners. You usually don't see individual insurance requirements unless it's a condominium. It's called an HO6 policy, and that would be in your recorded declaration and bylaws. But you want to know about insurance coverage. Is there coverage for liability if somebody slips and falls on the common elements? You know, is there coverage, a fidelity bond if there's fraud or there's theft from the community? You're required to disclose any lawsuits that are pending by the association or against the association. This has generally been viewed as not your average collection matter, right? So if you have somebody who's delinquent and you're suing them in general district court, that's not what they're talking about. They're talking about stuff that would materially impact the association. Whether or not you have that $500 may matter to your budget. I'm not suggesting it doesn't, but the whole association isn't going to go belly up because you don't get that $500. Whereas if you're being sued for a massive slip and fall during a snow removal situation that's $100 million, that may. So that's going to be something you're going to have to disclose. You also have to disclose any violations on the lot of the unit. Where this becomes a problem is many associations, and you see this with both professionally managed and self-managed, look at the front and walk away. So they look at the front and they say everything's fine and walk. And then they find the fence is incorrect in the back. It's not on the property line. There's a shed that's not approved. There's a deck that's not approved. You need to look at the whole thing. And that doesn't, in an HOA, that doesn't require massive entrance, but you do need to walk around the back of the property, look. In a condo, you're required to inspect inside the condominium unit because people could have changed the walls, the sides, made it a 3-bedroom instead of a 2-bedroom. So that is required. And the consequences are if you don't disclose this stuff and somebody buys, that purchaser now has a 3-bedroom condo unit. That purchaser now has a fence that's partially on the common area because you've got to let them know or you basically take subject to the way it is when you buy it. Then the sign restrictions, flag display restrictions, and solar energy collection device restrictions are all things that are kind of partially governed by federal law, partially governed by state law. Mostly the short version, and again, as Michelle said, check your source documents, right? But the short answer is you can't ban these things entirely as a general rule, but you can control them. So you can't ban the display of, say, an American flag, but it can't be blocking the line of sight when people turn the corner. It can't be, so large that it blocks your neighbor's windows. There are limits you can place on it, but you can't ban it entirely. And that's going to be community specific, and that's going to be something that the community needs to have regulations about. Also, you have to include board minutes and annual meeting minutes for the past 6 months. This practically acts to have you never include annual meeting minutes because your annual meeting, your minutes don't get adopted till the next year, so they're never going to be 6 months old. They're only going to ever be a year old, but that's what they have you including. And it's what's been adopted, not what's pending. So you could have had a meeting last night. You don't have to include those minutes. It's the last 6 months of adopted minutes. And then as we talked about violations, you have to include the actual notices you sent to the current owner. So you're not only inspecting for current violations, something that's happened recently, but you're also sending them copies of the actual notices that went to the current owner about this. You're also going to disclose if you have FHA or VA approval for loans. That's only with a condo. FHA and VA approve loans separately for individual homes, but for condos, it's the project is approved. And the failure to provide this resale package timely, and I understand timely is an issue with a self-managed association. Professional association managers have whole departments that churn these things out, right? But the individual, the self-managed, the 12-unit townhouse in Alexandria, it's every Saturday the board president sits down and does this. But the consequences of not doing it timely is there could be a penalty from the CICB. And you can also be prevented from collecting anything that was delinquent, and you can be prevented from requiring violations to be brought into compliance. So these are things to consider. I mean, as much of a pain in the butt this thing can be to put together, it really is very important both from the purchaser's perspective and the association's. So you say, I'm doing all this work, what do I get for it, right? The way this works, and the numbers you have up here are the numbers when the law was passed. Every year there is a consumer price index increase, and in the materials Michelle provided, it has what the current numbers are, and I think the CICB updates those on a regular basis. I've tried to do it myself with a calculator, and let's just not do that ever. But basically, this is the outline of the fees, right? So you have a fee for the inspection. You have a fee for actually producing the resale packet or the certificate in paper or electronic, and you can't charge both. You can't, if they say, what happens is a seller comes to you and says, I'm buying my house. I'm selling my house, and I need a disclosure package by Friday, and it's a Monday. Well, I believe they have, I'll have to look when we get further on, but you have a certain amount of time to produce it. And if it's a rush, you have an extra fee for that. And then you go out and do all this stuff. And when the seller says produce the packet, they say my realtor is going to pick it up and I want it in paper. Or just email it to Steve at this address. So depending on what they pick, that's what you charge. They can't get both. So if they want paper, they get paper. If they want electronic, they get electronic. They don't get both. And then these fees that are specific to self-managed associations, if the self-managed association can provide an electronic copy, they instantly kick into the other fees, the management fees. So you get more money for what you've done if you're capable of providing an electronic copy of the resale package. So it's to encourage that electronic copy. And then you have these rush fees. So if you want it within 5 days, you can charge an additional fee. If you want it delivered by hand or by overnight mail like FedEx, you can charge that fee. This post-closing fee that we mentioned earlier that you have to disclose in the package, that's a charging fee. And then the $50 update. Now, I didn't talk about the update information because there's like a paragraph this long in the statute about it. Like if you've done it, but it's been 12 months, but nothing's really changed, but it's kind of changed. So basically, an update can't just be the next week they say, actually, I found a new buyer and I want to do this. Nothing's really materially changed. The more time that passes, that's when you can provide that update because then you're actually changing the packet, right? You need a different 6 months of minutes. You need a different violation notice. You need a different budget or different income and expense statement. What's really important is the fees are collected at settlement. So they don't stroke you a check right there when they pick them up. They're collected at settlement on the settlement sheet. That's great, you say. But what if I don't ever get my check, right? It becomes an assessment on the owner's account. Who's owner?
Right.
Let me tell you. So I'm selling my house. I request my package. I don't pay you. I never go to settlement. I decide not to put my house on the market or I take it off the market. That becomes something that I owe because I'm still the owner of the house. It's an assessment on my account. Collectible is an assessment. You can lien it. You can sue for it. Do all that fun stuff that I do for a living. If I sell the house and it was never paid, now the new buyer owes it, and it's on an assessment on their account, and they have to pay, even though initially they weren't responsible for it. So it kind of travels with the property if you don't get paid. Now, that purchaser very well could go back to the seller and say, you never paid for this at closing, or go back to the closing company. That's not your problem. Your relationship, as with everything, is with that property and with that land and with the current owner. So they can go back to whomever they want, but it's on their account. And that gives you a means of collecting what you have not yet been paid but have done the work for. And like I mentioned, the fees adjust every 5 years by CPI, so those adjustments are plugged in on the CICB website. And you have to be registered in order to collect the fees. So this is kind of like you have to provide it electronically in order to get the good fees. You have to be registered with the CICB in order to collect the fees. That's just another way of them trying to get you to register. Oops. All right, so then you have the right to cancel. Yeah. So when can a buyer cancel? I'm the seller. I provide the resale package. I hand it to the buyer or the potential buyer. When he signs the contract, he has 3 days to say yes, no, maybe so. If it's mailed, you get 6 days. And the only remedy you have if you don't like anything in the package or something in the package is canceling the contract. If you go to settlement and never cancel the contract, it's over. You can't go back and complain. You've taken subject to that declaration, bylaws, rules and regulations. So you'll a lot of times see people who don't have resale packages for a number of reasons, unless their reason is the association was unable to provide one, then they're bound and you get whatever you get under the contract that is the declaration. And you can see they can cancel by mail, email, overnight delivery, and hand delivery, and depending on how they choose to cancel, there's a timeline in there, which makes sense. An email, it's probably pretty instant, whereas if you're gonna hand deliver, probably pretty instant. Mail, there's probably 3 days. The law loves to add 3 days whenever you mail anything. It's just what they do. Okay.
Okay, great. Stay up with me.
Yes, ma'am.
Okay, great. Thank you so much, Amy. That was a quick overview. We had a question about accessing some of the documents that are available for the presentation. We are going to make that available on our Consumer Affairs branch website. And then we'll have the information available for replay on Channel 16, and then the Facebook Live will replay as well. I had a question for you, Amy. You said that if someone doesn't get the resale packet, that they could report that to the Common Interest Community Board. How is that process? Do they have to go through the Ombudsman complaint procedure, or can they go directly?
No, they wouldn't have to go through the Ombudsman
Okay.
complaint procedure, because I don't think they have any way of knowing what it is or
Right.
have a copy of that resolution if they've never received a resale package.
Okay, all right. So they'll go directly to the Common Interest Community Board to let them know that that's a concern. Wonderful. Now, did anyone have any additional questions, or what brought you out today? I'm curious to hear, and we can have a conversation.
Yeah, I've got a question about the information that says failure to provide resale timely. The penalty, you cannot collect delinquent assessments or require violations to be brought into compliance. For how long? Is that until the resale package is provided? Or is there like a time that you can't do those things?
I think you can't go backwards. So if you don't provide let's say they ask for it and the sale is, April 1st, and you don't provide it until April 1st, obviously that's not timely because you don't have the 3 days to cancel because you're getting it the day of sale. And assuming the person complains, this isn't automatic. But if the person complains, then I don't think you could collect any assessments or deal with any violations as of there backwards. If the new owner then becomes delinquent, or the new owner, builds a deck at the front of their house, which is in violation with your documents, you could go after that. But I think they're talking about you can't really remedy the prior, which would normally carry over or be taken care of prior to sale, because you didn't provide the resale packet in the timely manner.
Okay, thank you.
The realtors in Northern Virginia provide a form to request a disclosure packet. What is the legal status of that form? Are they required to provide it, or could they just call you up and say, hey, Steve, send me a disclosure packet?
I think that's dependent on who you're requesting it from. I'm pretty sure the realtors do that for convenience. But I know every professionally managed company has their own form. First Service, Service First, KPA, they all have their own forms that you fill out either online or in paper. So I think that's just a convenient step for the realtors, which isn't a bad idea, but that's not a requirement on this end. That's what they're doing on their end. So they could, it's whatever you expect. There is a quirk in the law that's what I call it. There's a specific language in the law that says you have to have a written request for a resale package. It's only in one statute, not the whole thing. So it's a little weird, but I would recommend written requests, because then nobody can come back on you and say, I never asked for this. And a written request can be an email. But in this instance, we had someone who the seller asked for a resale package in the office, said to the manager, I need a resale package. Flash forward, nobody paid for it. And the purchaser saying, I'm not paying for it because there was never a written request.
I think the written request is a good idea also because a date time stamps it for you, and you know what your timeline is, and you can have documentation of that as well. I know that I receive a lot of calls from different realtors trying to locate different communities, and sometimes some of our smaller communities, they may not have an active board or an active person. So if you have some type of website, this is almost like general information, how to contact you to make this request. That will be a great effort to those reaching out to you for that information.
I'm the fellow in our HOA who prepares the BPOA documents, and am kept quite busy. Actually, we've been really successful in preparing a two-part document. And what we have is, if you go through the list of the requirements, a lot of this stuff is stuff that never changes. The declarations, the articles of incorporation. Once a year you update the budget, once a year you update the income expenses and whatnot. And so we have that in a giant 45-page PDF document, which is on the webpage. You can just go there and get it. And the other individual property, are you in violation, yada, 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 that goes out in a separate email that goes out. And the real estate agents and the settlement agents have been very pleased with that approach towards it. I recommend it to anybody. I know 33 years ago when I bought into this community, I got this stack of papers this thick of copies of copies of copies of copies of copies. And it was, and when I prepared this, I was going through the original documents from the courthouse and scanning them into the electronic format so we could go this way. And it was intriguing by how many typos there are in declarations, but you got to keep them in there because that's the way they are. So.
And I would say that some communities, especially the older ones, like to retype the documents. Like the declaration's 300 years old and there's a smear here and you can't really read it. So they retype it into a clearer format. As a lawyer, please don't. Because if you make any mistake and it's not matching, that's going to fall on you. And if you have the original, even if nobody can read what that word is, then nobody can read what that word is, and we're all on the same page. As opposed to guessing or remembering, or when I bought in 76, this is what it said, or this is what the developer recommended. It's just better to go with the source doc, even if it's a problem.
I appreciate you sharing your best practice. That's a great time for us to get together and say what's working well in another community. Amy, I had a call one time and I was curious about this. The individual seller had made the request for the packet, and I don't know, it seemed like it went directly to the purchaser, but the seller was unaware of the content. So does the seller get a copy along with what goes directly to the purchaser?
It's who they request to have a copy when the seller
so
makes
the
the
seller
request.
can make a request, send me a copy so I can see what's in it.
Right.
And I'm not going to get blindsided about what my purchaser is going to.
Or they can say send it directly to the purchaser or send it to my realtor. I mean, it's up to them. And like we talked about, you get a certain number of copies. And obviously, it's electronic. You can pretty much send it anywhere you want, right? I mean, that's the easy way. But yes, I mean, the flip side of that is, and this is the lawyer in me coming out too, is if it's your property, wouldn't you know? Like, what is there that you don't know that's in there? The only thing I could think is any sort of violation that you haven't gotten a notice for yet, but
and I
exists.
think that was the issue in this case.
Right.
Yes, yeah.
Is it permissible for an association to require that the check for the fee is on hand, that they have the check before they send out the disclosure packet?
No. The fees are to be collected at settlement. There is an exception to that in the law, and I don't remember what it is exactly off the top of my head, but it has to do with, I believe it's with updates. You can request the payment for the update right then and there. But the whole point is you're not supposed to have to cut a check right there. It's supposed to be able to come out of the settlement fees. And that's why you have that remedy of being able to put it on the account if it's not paid later.
Speaking of fees, they're kind of a pain, so we don't charge any. You go to the webpage, you download a 45-page document. That doesn't take anything. And then the preparation of the individual items that are applicable to the property, it probably takes us 30 minutes or something like that and zip it out. It's just not worth collecting money for that. So that's what we have dues for.
Well, you don't have to charge all those fees. That's the other side, and that's actually a good point. Just because there's a list of all the different fees you can charge, you don't have to charge them all. So maybe you don't charge anything unless they want it in 5 days, and then you charge the $50 expedite fee. Because maybe it doesn't cause you any problems. If you've got it all set up like this gentleman's talking about, and all you have to do is take a walk around Lola's house and see what's there and throw in the latest minutes, then it's not a problem. But there are other communities that feel very burdened by producing these things and feel like they've really spent, especially self-managed communities, because there's no manager over here to do it. You're doing it on your own time when your kid's at soccer. So they really want the fees, and I think one of the recent changes to the law was to make it so self-managed associations could charge the same fees as professionally managed associations. And I thought that was brilliant, because I frankly think that professionally managed associations are probably spending less time and effort on it
They have
than
their
the
systems.
self-managed ones. Yes. Yes. Also, I think inspection almost always falls on the board.
So with your inspections that you're doing as you're preparing, have you done a disclosure packet recently? within the past 6 months recently, this group? So when you're doing your inspections, the community owner will have gone through an annual inspection, and then this is an additional inspection to find out what's currently going on to make sure they're in compliance. Are you finding any concerns with that process on your end?
We have a pretty good system in place, which includes looking at the unit file to see if a deck that we saw was approved. The landscaping plan in front was approved, so it includes things like no application was submitted for this, alteration. So, and then making the appointments to go in inside the condos, I'd say, is probably the biggest sticking point.
Okay.
Particularly when you make an appointment and then they don't show up. That would be my only question is there any ability to have them pay for someone to have to go out to the property a second time, a third time, a fourth time to hook up with the...
It's not set up like that now. It's just a fee for the inspection. A lot depends on your own documents. Some documents provide that you can change the locks and go in if you need to go in, and this is a statutory requirement. So you could theoretically do that. I don't think most communities would want to do that. I don't know, but I think there's got to be a way to accept that from the resale package. Again, there's nothing statutorily providing that, but it seems to me if you're being prevented from doing what you need to do by the seller, there's going to be some sort of exception for that, as opposed to you just didn't, I mean, the difficulty I have is a community that didn't look at the backyard, and it turns out the fence was like 20 feet into the common area, and they're like, we don't know when that happened. We approved the fence 20 years ago. Well, sometimes in the last 20 years, your fence got moved, and now it's going to stay there. But that's something that they could easily have walked around the community to see, whereas inside a unit, you don't know. And I would say you probably take subject to the violation if there's a violation in there.
But we put a statement when we have not been able to get in touch with them and the due date has come and gone. We issued the inspection form saying that we were unable to gain access for inspection, therefore the buyer accepts responsibility for any violations that may exist, which gets us a phone call to get out there really quickly and inspect the home. So that works pretty well.
And that's exactly right. And I think what's the frustration is not only in the fact that you have to go out more than once, but is also that you're selling your house. Like, you want to do this. Why are you standing in my way? Like, I'm just trying to do what I have to do to make it so that you can sell your house. So that could be frustrating, but hopefully it doesn't happen too often.
Okay. Any more final questions? Well, thank you very much for joining us today here at the Government Center, also for streamlining with us on Facebook Live. And then if you have any questions or follow-up concerns, please feel free to contact me. My quickest email is ycyc@fairfaxcounty.gov. And I do my recurring bi-monthly television program. Our next program will be Your Community, You're Connected Association Meetings. And it will air live on Fairfax County Government Channel 16 on next Tuesday, March 12th from 7 to 8 p.m. So you have some information about that. Again, the information will be made available on the Fairfax County Consumer Affairs Branch website. And thank you again for joining us in celebrating National Consumer Protection Week.
Thank you.